To Senator Durbin's original question, can you just confirm to the committee that I was a very mousy, wallflower, unopinionated, and afraid to express myself in law school?
Thank you, Senator. I wish I could do that.
It was worth a try. Worth a try.
Reminder that the witness is under oath.
You've been involved in, as a lawyer and as a judge, about 75 trials. Is that right?
Correct.
A lot of cases never make it to trial. They either settle before they get there, or in many cases, they're resolved by a dispositive motion. In many cases, summary judgment is involved. The parties get to the point after conducting discovery that they conclude there's no genuine issue of material fact. And one of them files a motion for summary judgment. When there's a close case, or an arguably close case on a Rule 56 motion, do you have any opinion on what's worse, granting a meritorious dispositive motion under Rule 56, or failing to grant one that is meritorious?
Well, Senator, I appreciate the question, and I'm certainly cognizant of the dilemma that you have posed there. And I can tell you that I find no virtue in either option that you've given me. I have litigated summary judgment motions as a lawyer. I have ruled on them as a judge. And it is my intention in all of those circumstances to get it right. It is not my inclination to take the easy way out. And getting it right on summary judgment is a heavy lift.
Right.
But I study the issues carefully, and I'm aware that some believe that having one's day in court is the automatic out in a close case.
And what do you mean by that when you say having one's day in court?
Meaning denying the motion for summary judgment.
And thus allowing the case to proceed to trial.
Correct. If you deny the motion for summary judgment, the case proceeds. I think some believe it will likely settle, and so that's the safer option.
So is that what you referred to a minute ago when you said the easy way out?
Correct.
Because it's easier to deny the motion for summary judgment than to grant. Why is that?
Well, because it takes a lot of heavy lifting to carefully review the filings and to write the significant order in support of a granting of a motion for summary judgment.
So that's more likely to involve an opinion rather than just a simple order saying there's...
Correct.
Yeah.
And judges with busy dockets, I think everyone wants to get it right, of course, but judges with busy dockets may err on the side of caution and say, let me deny the motion. That's a quick, just a really quick order. But I believe that the more courageous approach is to carefully consider those issues and really to make the ruling that is demanded by the law and the facts. And were I to be so fortunate as to be confirmed into this role, I would continue to my commitment to not taking the easy way out, and to making the brave decision in whichever manner the law and the facts support, and then standing behind that, whatever comes.
So if I understand you correctly, neither one is more defensible than the other. They're both bad. They're both equally indefensible.
Yes, absolutely.
The temptation is greater to deny the dispositive motion.
In my experience, that is absolutely the case, Senator.
And so, in other words, the judge needs to look out for that temptation among judges, because if you do that, the case may well settle long before it gets to trial.
Correct.
By the way, what tends to take more time, your average criminal case or your average civil case, or is there a difference?
In the judicial or in the lawyering context?
In the judicial context.
In my experience, civil cases have more nuances, more heavy lifting in terms of the handling of those matters. Certainly all are important, and I give full attention to all matters before me. but they usually have the more dense subject matter in terms of preparation.
Right. Some of that probably relates to the prevalence of the dispositive motion in civil litigation. Not as much of that. You have other kinds of motions.
Certainly.
Trial.
Certainly.
All right. I see my time's expired. Thank you. I was hoping you could confirm the Wallflower thing, but, worth a shot.
Senator Kennedy.